these old men are forgetting easily. So, but we'll have to look at the weather and all of that. So that will have to be done. It's just that we're working with old men here, of Mr. Ngoma and the rest. So members will have to come back to you in terms of that, but it will have to be soon. Another issue that we'll have to put in our agenda is the Broadcasting Amendment Act this year, Honorable Kalako, so that we finalize it. Surely this one of FPB will have to go through maybe first term, because we're done, the processes are done. It's just to take it to Parliament and then it's finalized. But another act, Amendment Act, will have to be through this year. So those are the issues, members, that I thought we'll have to round up with, so that as we adjourn the meeting, at least we are clear on those matters. Program will have to be circulated to you. The last one is the critical one of the end of March, the training with VETS University. In your program circulated to you, we have 26 to the 30th of March, and we can't confirm anything if members don't confirm. A lot of money is going to be paid there, but we need to create space in our programs to be part of that training. That training assists us in understanding the sector itself. So we'll have to confirm. The secretary will check all of us one by one, so that we can confirm with VETS before the end of this week. Those who are here surely will have to confirm whilst we are here before we leave. But thank you very much, members, for coming, and thank you very much, our guests. And the meeting's adjourned. We can go home now. Thank you.
And this matter is something that's going to preoccupy Parliament, not just about Steinhoff, but other corporate scandals. And our feeling is that you know, we can't sit back and, as Parliament, fold our arms and say, well, there's the Financial Services Board, there's the Johannesburg Stock Exchange, there's the Independent Regulatory Board for Authorities and so on, the South African Reserve Bank. They must hold to account Steinhoff and then report back to us. Yes, yes, they must do that, but our job is to ensure that we as Parliament hold those people vigorously to account, but also Steinhoff International, not least because the Government Employees Pension Fund is affected, and as many of you know, it's a defined pension benefit, which means ultimately, if there are material losses, it's the fiscus that will have to come to the rescue, which is overstrained, as you well know already. So we have been engaging with Steinhoff. We're saying, yes, we know these regulatory bodies are primarily responsible for investigation. They are legally mandated to do so. And we understand that you have court actions pending. We understand, too, that there are things you cannot say because you'll say there are investigations pending, there's prosecution possible, and so on. All that we understand. But within those constraints, we are utterly clear. Steinhoff can at least explain what you are doing, the current leadership, to mitigate the losses, what you are doing to address the problems, and we think that should be done. And within those constraints, we mean to hold you to account. Now, we've been engaging with Steinhoff on these matters, and I think we've reached some consensus around that, but that's a matter the two co-chairs and members of the committee will have the final say on. And we want to stress, though, our concern is not just the government employees, but workers, wherever they are, who are going to lose out, if not lost out already. And not just them, but any sector of South African society. And it's in that context, therefore, that we have these hearings. Our concern, too, is, of course, job losses, possibly, in Steinhoff companies in this country. Now, from the regulatory bodies, what it is we are asking? Well, basically asking, what have you done in terms of your legally mandated role since the crisis broke out? What have you done? What are you doing right now? What is the scope or terms of reference of your investigation? What are your timelines? When will you report back to the public and to Parliament? What can we do as Parliament to hold you to actually assist you if there's some capacity or other concerns you have? What is your cooperation with regulators in the Netherlands, Germany, and so on? With the Johannesburg Stock Exchange, needless to say, we're interested to know what is it that you're going to do in respect of working with your counterparts in Germany and the Netherlands and so on. As we've explained, the aim of this briefing is not to supplant the role of the South African Reserve Bank or the Independent Regulatory Board for Auditors or the FSB. We don't have the technical and forensic capacity to do that. But we are responsible, as the three committees here and the Trade and Industry Committee and possibly other committees, to hold these regulators to account. And we would like you to move swiftly, even if thoroughly, swiftly and decisively on this matter. And where there are irregularities, the appropriate structures in the criminal justice system, we believe, should attend to them, though that is something that the relevant committees will, needless to say, have oversight over. Now, we've called the GEPF and the PIC here, because, of course, they're answerable to Parliament, and we need to ask them, we will, in fact, ask them, what is it that dictates, we have as two committees, I think, all three committees, I think, been looking into how the PIC and the GEPF operate. I think people might know there's a private member's bill and a parliamentary committee bill on strengthening the PIC and holding it to account more effectively to Parliament. These two bills are being processed at the moment, and we hope before, well, reasonably soon to have finalized that. So again, with the GEPF and PIC, we want to know what is their sense at the moment. Obviously, it's an unfolding story. What is their sense of the losses they've experienced? What are they doing about it? What lessons have they learned? How will they apply these lessons to ensure they are more careful about investments? Of course, we're acutely aware that part of the problem is the free market system. You take risks and then you suffer losses, but you also take risks and you secure gains. That's the nature of the free market system. But even within the context of a free market system, surely the parliaments and the governments of those societies have a responsibility to the public out there, to workers, whether they're government employees or whoever. Now, we want to stress also that this is not a public hearing, and whether we should or shouldn't have a public hearing is something we should collectively engage around, bearing in mind that there are other bodies that are investigating, and they will also, needless to say, or presumably, they will invite the trade unions and other parties affected to hear their case. But we will look into that possibility. This is no more, we must stress, than an initial public hearing. A public briefing, sorry. And, you know, we really want to, at the end of this day, if you like, or shortly hereafter, establish what, if you like, is the role of the different regulators. To what extent are they cooperating? What would be the role of Parliament? In particular, what would our three committees and Trade and Industries Committee do collectively, and what we would do in our own routine oversight work? So we meet at times collectively, but in our routine work of oversight, say in the case of Standing Committee on Finance, what is it we must do to measure what's happening in respect of the regulators answerable to our committee, and in fact the PIC and GEPF? We also think that it's possible that for the Standing Committee on Finance in particular, we need to look at do we need to have changes in the policies and regulatory framework that apply to the regulators. For example, just to throw out one thing that obviously the FSB anticipates, presumably, it's said that the German regulators some 2 years ago began to signal that, you know, something's wrong at Steinhoff. What did our regulators do since then? What happened in the past 2 years, and so on? So we need to look at whether there needs for changes for policy, changes for regulation. The committee will also confer with other committees, trade and industry in particular, who ideally should have been here. I've been engaging with the chairperson, but I haven't reached her in this regard, around where we take forward, because the Companies Act requires the Trade and Industry Committee to oversee the structures that are concerned to ensure the implementation of the Companies Act. And then on managing time, needless to say, we have 4 committees here. I think Yvonne Pinky Poza, are you here? We can't slot you in here, but the chairperson, welcome. Okay, welcome also to the Appropriations Committee. They felt they'd like to come. They don't want to be a formal part of this process, but members, as you might know or don't know, are allowed to attend any committee meeting if they're members of Parliament and participate. So Yvonne, even though you're here informally, your committee members are welcome to put any questions, but we want to manage the time effectively. We've increased the time in the latest program, but at the end of the day, this is not the be-all and end-all. We have to essentially go towards a program at the end of this meeting. That's our primary things. There are a lot of things we'll carry over. Over to Temba and Castle for what they want to say.
No, I think you covered us, Chair. We should just proceed with the program from my point of view. Thank you.
Yeah, thank you, Comrade Chair. Just to emphasize from our side that the involvement of public funds is always a trigger for our interest as the Standing Committee on Public Accounts. And it is important that whenever financial malfeasance occur, we need, especially as Parliament, we need to be seen to be acting without fear, favor, or prejudice. And that this situation does assist us, for once since 1994, to clear the virtual Chinese wall between public and private money, and the assertion that all public is bad and all private is good. Because in a capitalist setup, such separation is purely artificial, doesn't exist. Actually, it is the base that influences the superstructure. So it would have been amiss if we had merely called the public sector regulatory bodies without involving Steinhoff to at least, before we even engage them, to say to us, this is what happened, this is how it happened. And for Parliament as the representative of the people to be seen, to be holding everybody to account for whatever they are doing, especially when the laws that we pass have been transgressed. So from my side and also from my comrades in the committee, we're very much looking forward to this engagement, and we clearly understand that it's merely the beginning of a process of interaction, but whose ultimate end should be to identify what went wrong, who did wrong, And if that be the case, then for those people to be held to account to the full extent that the law provides. Thank you, Comrade.
Well, if there's any signal here, we have chairs stuck by the time. We are 3 minutes ahead of time. And so I ask that we swiftly move forward to the first. Oh, you want to note the apologies? Yeah. Apologies from the different committees of members who are not here.
No, thanks, Chair. From Public Service and Administration, the following have submitted apologies. Honorable Dlamini Dubazani, Honorable Kosa, Honorable Kasim, Honorable Ntombela, and Minister Mutambi. That's all from our committee. Thank you.
I think from Scopa, we have Comrade Vincent Smith and Comrade Ntabiseng Kuno. Those are the two comrades that are not with us today. Thanks.
Can we move on, please? Can we have Steinhoff International? Sorry.
Chair, just time is of the essence. We want to move on. I just want to place it on record that two of the most important witnesses from Steinhoff, Marcus Jooste, the former Chief Executive Officer, and Ben Lecrancy, the former CFO, are not present. And at future hearings, we may need to consider summonsing them to appear. I just wish to place that on record.
No, I don't think there's any difference here. We did discuss this in the Standing Committee on Finance to a fleeting extent. I think Mr. Wiese is here. There he is. He's here. The three committee chairs will confer with the Parliamentary Legal Services Unit, and in fact, the House Chair, Mr. Cedric Frolic, is going to coordinate this process henceforth. So. Oh, yes. Mr. Matale likely points out, by the way, we're co-chairing, right? So the chairs will just zip in, you know? There's no need to do it via me. But as his spokesperson, Mr. Matale's spokesperson, Comrade Matale's spokesperson, I would like to say that he points out that there may be people who were meant to be here from the delegations that are not here, because we got a list of people late yesterday and so on. So is everybody here was meant to be here? Anybody wants to send an apology on behalf of anybody who's not here? Okay. I'm no more serving as spokesperson for Comrade Matale. He'll speak for himself now.
Not necessarily. I was saying that we are dealing with apologies.
Yeah.
We have submitted apologies from public service.
Yeah.
Scopa have done so.
Yeah.
And everybody's here from your side.
Yeah.
We are meeting Steinhoff and other institutions. They should be able to talk to that item because it also involves them. That's why I was saying, before we deal with what Honorable Menir is raising here, let's hear what they are saying. If there is no apology from their side, then that becomes relevant to what he has raised. Thank you.
Yes, I think this is a matter that will also, at the conclusion of the meeting, you can mandate the chairs to look into. I don't think there's any disagreement. Over then to Steinhoff. You'll introduce your delegation? Yeah, thank you. We'll monitor you in terms of the iPhone time. Yeah.
Okay.
Thank you.
Thank you, Chair. Maybe just by way of opening, to thank the committee chairs for their opening remarks. I think we all make assumptions as to how we think about what you prioritize, but to hear it firsthand is certainly very useful. So thank you for those opening remarks. I just want to start by saying good morning to the chairpersons of the various committees, the honorable members, members of the media, and members of the public. We welcome and thank you for the opportunity to provide some insight as to where the company is today, where it finds itself, and some of the actions that we've undertaken to date. I will start by introducing our delegation, perhaps starting with me. My name is Heather Son, and I'm the acting chairperson of Steinhoff NV, which is a Dutch registered company. It is listed, a primary listing on the Frankfurt Stock Exchange, a secondary listing on the JSE. It has 130,000 employees globally. 50,000 of those employees are in South Africa, and 68% of the shareholders in Steinhoff NV are in South Africa. The other members of the delegation are Johan van Zyl, and on the 11th of December, we formed an independent committee of the board. The reason for forming this committee was to be able to respond tactically and quickly to the events that were unfolding within the company. And we thought that a member of a few members, 3 members made up of myself, Steve Boyson, and Johan van Zyl, would assist us to represent the full supervisory board on all the daily, not only decisions, but guidance and work that needed to be done between ourselves and the management board. Steve Boyson, I mentioned before, who is chair of the audit committee, is also in attendance. And then members of the management board. It's a idiosyncrasy of the European governance structure that there are both management boards and supervisory boards. The supervisory board is made up of non-executive directors who have oversight over the management board, and where we would have in South Africa those two combined. In Europe and certainly in the Netherlands, where we have to comply on these governance structures, those two are split apart, and the management board is an entity that has oversight over the executive committee, what we might refer to in South Africa as the EXCO. So the members of the management board that are present here today are Louis Dupree, who is our commercial director on the management board, and Dani van der Merwe, who is the acting CEO. Chair, those are the members of our delegation here today. There's a short content page. I hope the presentation has been distributed. I won't go through the content page, but it gives you a sense of what we will talk about. I think first and foremostly, we need to start with the commitment of the company, because we've had to reset. And we've reset to a point as to what it is that we are committed to, which is the basis from which this team is working from. And I think the first thing to say is that we are deeply aware of the impact that this has had on investments, on pension funds, on the reputation of the company, on the Steinhoff brand, on business in South Africa generally, and on our nation. Our commitment is that we will uncover the truth as this team. We will fix what went wrong, we will prosecute wrongdoing, and we will communicate fully on an ongoing basis. I think there has been some frustration about our communication in the past. We are constrained. Much of our information that we could share is price sensitive. We also have concerns about a forensic investigation. We don't want to compromise the matters surrounding the cases that we may need to follow, and we don't want to compromise our processes. Our view is that as these matters evolve, we will be in a position to communicate more freely, and we intend to do so. We have cooperated fully with all our regulators globally. We are working constantly as part of our commitment to maintain and improve liquidity of the group. As you can imagine, the events as they were announced and the share price decline, we faced a liquidity crisis, and we had to move very quickly to ensure that that the businesses can continue to trade. We also look not only at our immediate crisis, but how we might be able to return to maintain and restore some value to shareholders. We also need to look after the 130,000 employees globally, and the retention of their jobs have been paramount and will remain paramount to the work that we do going forward. I think just to reiterate and explain a little bit more about our communication, and it is just given the gravity of the situation that Steinhoff has been in since the events of December 4, 2017, and subsequently, we are deeply constrained in what we can say, legally and otherwise. We are working on account restatements and a forensic investigation, and this work is ongoing. We say these things on the advice of the company's lawyers. I must say that we come to this gathering open And if we could communicate everything today, we would communicate. We understand the seriousness of the situation, and we also understand the intense public interest, broad interest in what is going on here. We completely understand that. But we do remain constrained, and therefore our commitment is to disclose on an ongoing basis and even to come back to Parliament as the events evolve and we don't find ourselves in such a compromised position in what we might declare publicly. It does not mean we are unwilling to communicate. We have to advance the work far enough to be able to communicate publicly without harming or constraining potential prosecutions and other actions that may arise. We would have preferred, it is in my nature, it is in our nature to answer questions fully. But I hope you understand that the time for this will arrive, and we would be happy to come back and tell you more about that as it evolves. Another point we need to make is that we are here as representatives of the company of Steinhoff. We are not here in our personal capacities here today. We will, as far as we've made the presentation available, I trust everyone has a copy, and we've also put a bundle of the 33 statements that the company has made publicly since December 4, and that is available for your review. The chronology of events, as Chairperson Karim referred to earlier, what has happened as far as we know. The CEO resigned on the 5th of December, and there were postponement of our financial statements, and this triggered a significant decline in our share price and a liquidity crisis in the company. Our credit lines dried up, our suppliers struggled with credit insurance, and also we ran the risk of getting into credit defaults. This was the situation into which we stepped, and we needed to create some stability in the company. The announcement of the 5th of December, the company confirmed that PwC was appointed to conduct an independent forensic investigation to uncover the facts independently of what went wrong. We appointed international financial and liquidity advisors, Moelis and Alex Partners, on the 10th of December to assist globally with our companies to be able to create the stability around the liquidity challenges that we were facing. We also appointed Linklaters and Worksmans as legal advisors, and I think it's also important to note Africa Retail Limited was able to produce and issue annual audited financial statements on December. The board was established as a response to these tactical exchanges that needed to happen on a daily basis, and I was appointed as the acting chair of the company on the 15th of December. We then had to go to work to strengthen the management board, and I alluded earlier to this binary governance structure. And the management board was then comprised of Dani van der Merwe, who took on the role of acting CEO, Alexander Nodal, who is the CEO of the businesses in France, Conforama, and he became the deputy CEO, and he brought the very critical European experience to that management board. Louis Dupree was appointed as the commercial director onto the management board. Further appointments were made on the 4th of January. Philip Dipperink, who was CFO of Steinhoff UK, who maintains that position, but now takes on the responsibility of CFO of the group. And further, Johan Geldenhuys was appointed as the head of Treasury. Some of the actions that we've taken to date. I think it's important to note that in the initial instance, PwC was given an unrestricted scope. So the mandate to PwC was to cast the net wide, to leave no stone unturned, to make everyone the subject of a look-in. Everyone could be under their scrutiny, and then to define what their scope would be. There was no limitation on the PwC initial mandate. We are happy to progress. And in the next few days, we hope very soon, our hope is this week, they will be able to give us a view on what the focus of their investigation will be. We are working with Deloitte to finalize the 2017 consolidated financial statements and the restated 2015 and 2016 statements. We understand that this is incredibly important for the public and also for trading in our share. Steinhoff has cooperated fully with the regulators in all relevant jurisdictions, and we will continue to do so. Our leadership has been reorganized. We will continue to strengthen the leadership team and are in the process of appointing a chief restructuring officer. You will understand that the management board was running a very particular business before the events of December 4, and then went into an entirely different environment in the days after that. And we have to create more bandwidth for management to be able to focus on businesses trading and continuing so that we maintain that value in the company, but also have a chief restructuring officer that can help us with matters that pertain directly to restructuring and dealing with our financial creditors. It is also important to note that all subsidiaries are trading. 12,000 outlets worldwide open every day, including over the key December trading period. We are also continuing on the supervisory board to strengthen its independence. We have had some departures, and we are also in the process of interviewing candidates. We are looking for international, retail, business, and government expertise, and we hope to make those announcements shortly. We are entering the next phase of broader lender engagement and are now in a position to develop some strategic options for the company. The initial step was to try and create stability, some space, and then to start considering what our strategic options are as we move forward in a considered and controlled way. We will continue to manage the liquidity of the group and its underlying entities by making use of various liquidity measures. Further to our actions to date, we are in a position to announce that last night, the chairman of the audit committee reported transgressions to the authorities in terms of the Prevention of Combating of Corrupt Practices Act 2004, referred to as PRECA. Based on our investigations to date, we have reported the former CEO, Marcus Jooste, to the Hawks in terms of Section 34(1)(b) of PRECA on suspicion that he has committed offenses thereunder. The matter is now in the hands of the Hawks for further investigation and prosecution. The question that we considered was what went wrong and could it have been prevented? In December 2017, our auditors Deloitte advised us that they were not in a position to sign off the 2017 consolidated financial statements. We announced on December 7th that we are investigating the validity and recoverability of non-South African assets totaling some 6 billion euros. We don't know at this stage if the crisis could have been prevented. The PwC forensic investigation is ongoing, and only once it has been finalized will we be able to publicly disclose material findings, determine what went wrong, and take steps against those responsible. The scope of the PwC forensic investigation, as mentioned before, is unlimited and includes all supervisory, management, and management board members, including the audit and risk committee members. We will share the key findings with regulators and with Parliament so that the lessons learned from these events and processes can be applied. The effect on the share price decline on the public and private sectors: in 1 week, between December 4 and December 11th, the Steinhoff share price declined by nearly 85%. The sharp decline in the Steinhoff share price affected all shareholders in both public and private sectors. A third of our shareholders are outside of South Africa, as mentioned before. 68% are South African. As Steinhoff was one of the top shares on the JSE, it featured in tracking indices, and that are followed by investment funds, including the PIC and the GEPF. We are working to stabilize the group and restore trust. It's not a word we take lightly, and we believe that creating greater independence, to explain as far as possible what we are doing, to say what we are going to do and to follow through on that, to leave no stone unturned, and to take the necessary actions, maybe one step or some of the steps in that direction. Securing the future of the Steinhoff businesses is the process by which we intend to protect and restore value to shareholders. I'll now hand over to Louis Dupree, who will give some comments as well.
Thank you, Heather. Just morning all. Just to give you some indication of who I am and where do I fit into the picture. I joined the group on the 1st of June last year as the group legal counsel. And after some 20 years in private practice as an attorney, and on the 19th of December, I was asked by the supervisory board to join the management board, which position I've accepted, and I've been serving as a management board level member since then. I've also been asked to step onto the board of STAR during the course of last week, which position I also accepted. I think, just to maybe preempt one or two of the questions, is in the light of the disclosure that Mr. Son has just made, is Mr. Marcus Jooste is most definitely not part of this delegation, and he's got no relationship with Steinhoff, the company that is represented here today. Mr. Ben Legrandsie is still on a consultancy basis with the firm. He is, however, not a director of the company and does not act in any management position within the company. If I can then take you to a slide, sorry, just one back, just maybe some summary on what is Steinhoff and what does it represent and where does it come from. Is Steinhoff has over the last 20 years become the second largest furniture and home goods retailer in the world. It was founded in 1964 by a gentleman by the name of Bruno Steinhoff, from there the name of the company, and he introduced these businesses to South Africa in 1997, and Steinhoff International was thus listed on the Johannesburg Stock Exchange in 1998. As the business grew and further expanded, Steinhoff was listed on the Frankfurt Stock Exchange in late 2015. The group has become a global group with, as Mr. Son has indicated, employs some 130,000 people worldwide in some 30 countries, and there are approximately 12,000 retail shops that open every day of the week. Something about the company. It is, and I think it's important for the members of these honorable committees to take note of this, that Steinhoff is a company that is registered in the Netherlands. It is, as Mr. Son has indicated, governed by a supervisory board, and the day-to-day management is done by a management board of the 4 members that Mr. Son referred to earlier. The primary listing is in Frankfurt with a secondary listing on the Johannesburg Stock Exchange. The detail read the shareholding has been given to the honorable members, but we thought it would also be helpful to give you some indication as to what the top 5 shareholders in the company was as of 29 December 2017. We do anticipate that those might have changed substantially since that date, and they are available on the screen and in the packs that have been handed out to the members. If I can then ask you to turn to the next page, dealing with the group overview, just to give members some indication of what the extent and what this group entails. So you'll see at the top, honorable members, that we've got Steinhoff International Holdings, the Dutch company, at the top. On the left-hand side on the screen, you will note that there's blocks in yellow. That is the African structure, and those consist of, we've listed 2 of the main entities there called STAR, where there's a 77% interest in. It's a JSE-listed company. And then there's also interest in CUP, a 43% interest in that company, again a JSE-listed company. There are obviously other assets, but we, for present purposes, due to the size of those, not included them. Then to the far right-hand side in grey, members will see that there's an entity called Stripes US Holdings, and that holds the interest in Mattress Firm, a business that operates in Northern America and opens some 3,500 shops every day. In the middle of the picture, we've got 3 companies that are registered in Austria, and they in turn hold 3 clusters of assets. The first is a property investment company called Hemisphere that owns properties all over Europe predominantly, and is the landlord for many of the shops that are operated by the group within the European cluster. Then on the European businesses, this is a big part of the business, and I highlight 3 of the businesses there: Conforama in France, Poundland that operates in the United Kingdom, and then Pepco that operates in the old Eastern Europe. And then on the Australasian side, there are 5 businesses that operate predominantly in Australia and New Zealand. Then, if I can maybe turn to Steinhoff and its BEE partners, a broad-based employment share scheme known as Sikla Sonke was launched by the group in December 2008. The employees who participated in this scheme owned their own shares over a 9-year period. Just to give some runway on the nature of the scheme, it was a fixed price scheme, and it was concluded in the last quarter of 2017. When this scheme was closed, some 1 billion rand in funds was paid out to approximately 25,000 people, who were all employees one way or the other of the Steinhoff Group. Those payouts was therefore unaffected by the decline in the share price. Then, dealing with the current position, Lancaster is a BEE shareholder in Steinhoff and in Star. We are unfortunately unable to assess the impact of the decline in the share price on their investment, but what we do know is that the Lancaster Group still retains their shareholding in Steinhoff. If I can then turn to a very pressing matter, and it's a matter that is of great concern to the company. It was something that we as a management team have spent literally days and weeks on over the last 7 or 8 weeks. After the events of December 2017, essential working capital, especially in the international clusters, largely dried up. The access of the operating businesses to their banking facilities was severely constrained. The access to credit insurers, in other words, the insurers of the suppliers, withdrew their lines. And this resulted in many of the businesses, again, especially international clusters and with a predominant focus on Europe, were unfortunately not in a position to meet their day-to-day financial obligations. Closer to home, the South African businesses were luckily self-funded and did not have these liquidity constraints. We have had several meetings with our lenders and credit insurers over the last 8 weeks, and they've been briefed fully on a confidential basis on the ongoing liquidity constraints that the group face, and these briefings took place on 19 and 21 December 2017, again on the 11th of January 2018, and then last Friday in London again. We have, and we are glad to report this morning, we have the support from our lenders, and the majority of the international operating subsidiaries have managed to arrange their own working capital lines, and we have announced these events in the press over the last few weeks. We were also fortunate to announce on the 26th of January that the immediate operational liquidity requirements have largely been addressed, and in addition, we are at a holding company level got some stability. However, it is important for these honourable members to note that these this situation is a delicate one, and the discussions with our various lender groupings, both local and international, are ongoing. But as I said earlier, it is also just as important to note that we have managed to secure near-term liquidity, and the businesses are operating on a daily basis, and they can meet their day-to-day commitments. There were specific concerns in the Austrian businesses, and we managed during the course of last week to resolve those. And a specific business was announced on Monday by the name of Kikalina that operates predominantly in Austria, and some of the Eastern Europe companies have now got a going concern prognosis for the next 12 months. Then, lastly, before I close, I think it's also important that I, on behalf of the management team, reaffirm the commitment that Mrs. Son has given on behalf of the Supervisory Board. We, as the new management team, are deeply aware of the impact on investments, pension funds, and obviously the reputation of the company, the various businesses, our business partners, and the South African nation. We do undertake, as a management team, to uncover the truth. We will fix what went wrong, and we will institute the necessary steps to prosecute those that were in the wrong. We will, to the extent possible, and as soon as we are in a better position to do so, communicate this fully to the market and to the public. We undertake that we will fully cooperate with regulators, and to the extent that any of the regulators that are present in this room feel uncomfortable that we are not fully cooperating, we undertake as a management team, and I believe I can say so on behalf of the supervisory team, that we will rectify that, and we will make sure that the cooperation is full. What is important for the businesses, and to ensure that some value is ultimately preserved and unlocked, is that the liquidity and the underlying businesses have to be preserved. That is the only way that we are going to make a difference, to make sure that the retail outlets can open, that they can do business, and that the business can be stabilized. Included in this, as Mrs. Son said, are the 130,000 people that we employed and their families that depend on their employment. 50,000 of those are in South Africa, and it is very important for us as a management group to ensure that these people retain their jobs. I might be speaking out of turn, but to the best of my knowledge, not one person in South Africa has lost a job since the 4th of December as a result of this. In closing, we are here to help, except Mr. Jooster, as that honourable member said. We are here to help, and we intend to be part of the solution. Thank you, Chairs. We are welcome to opportunity, obviously subject to your direction, but we're very welcome to take questions.
Can we have Mr. Wiese, please?
Want me to move forward, Chairman?
Yeah. Thank you, Chair. Ladies and gentlemen, I didn't really prepare for a presentation, but perhaps it will be helpful for me to give some broad overview of my business career, philosophy, and how I got involved as the major shareholder in the Steinhoff Group. I've been fortunate enough over the space of 50 years to build, together with other people, some very significant corporations in South Africa and abroad, employing tens of thousands of people and creating very substantial wealth for all its stakeholders. To give but one example, the core of my business was the PEP Group, founded in 1965, with shareholder funds of 250,000 rand, and over the space of that 50 years, with one or two small rights issues along the way, and I'm really talking of 10 to 15 million rand, became a corporation worth almost 60 billion rand and employing 30 to 40,000 people. Now, I've always had a specific philosophy in terms of building those businesses together with thousands of my employees, and that was that we adhere to principles of integrity, professionalism, etc., creating the right atmosphere, but always on the basis that there must be full trust in the management, because I don't know how else one built a business. With the correct systems in place to do oversight and make sure that things do not go off the rails. I got to know Mr. Marcus Jooste in 1982 when he was an article clerk at the firm who at that stage were auditing one of my companies. I was impressed by him at the time as an energetic young man, well qualified, but he left Cape Town in the mid-80s and I had no contact with him, perhaps once or twice over the years. In 2011, I sold a property, Landsrack, in Stellenbosch, and a block of shares that I then held in PSG. I sold to the Steinhoff Group and became a shareholder, a smallish shareholder, having watched the progress of the company over the then 13 years that it had been listed. I thought it would be a good investment. In 2013, I was appointed to the board of Steinhoff, which gave me an opportunity to observe how the company was run, how it was managed, how the corporate governance was dealt with, the caliber of the people on the board, some of the most prominent business people in South Africa, highly professional with fantastic reputations. I'm making that point to get to why I did the deal in 2015, in terms whereof I sold Pepkor, as I say, for almost 60 billion rand. I can't remember the exact number. Sold it to Steinhoff in exchange for Steinhoff paper, which made me then the largest shareholder in the group. I was very confident that it was the right move for me to make. I was then 75 years old, and it is public knowledge. I made the statement several times that my intention was to consolidate all my business interests that would fit into the Steinhoff mold, into Steinhoff at some stage. And I'm sure members who follow financial affairs will be very aware of that. So I was happy to do it because I was happy with the management and happy with what I saw, and it was coupled to a vision that we shared with other large co-shareholders to build from South Africa what we liked to refer to as an African champion, to become an internationally recognized and sizable retail player. That was the vision. And things went very well. The businesses did well. There were the normal hiccups. I then decided, after 2 years, to also sell my interest in ShopRite into the group through a complicated structure, which most people will have taken note of. And we were in that process when this bomb exploded, which, you know, literally came like a bolt out of the blue. I've explained to colleagues that normally when you're in a business, you're responsible, you can see the problems coming. You become aware of them. The sales go down, the liquidity dries up, people start leaving the sinking ship, and you can take corrective action. In this instance, it was literally a bolt out of the blue. Now, from my perspective as chairman, the first time that I became aware that there was a serious difficulty, and may I just at this stage, Chair, say again that I'm very conscious of what I'm advised not to say because of all the reasons explained by the people who presented before me. So I have to choose my words very carefully, but became aware of the impending problem literally 3 working days before the matter had to be, the accounts had to be finalized for the board meeting of December. It was absolute turmoil, and fortunately I had Dr. Boysen, the chairman of the audit committee, and lawyers and advisors around us, because we were all knocked very badly to how do we proceed. We decided then, on the second day after the auditors had alerted us to the alleged irregularities, we decided to appoint PwC as a forensic investigator, alongside the statutory auditors at Deloitte, and that's when we started making the announcements and all the unhappy occurrences happened. I skipped out one part, and that is that in September 2016, apart from the 30 billion rand investment that I made in Steinhoff as a consequence of the Pepkor deal, I underwrote the raising of a capital issue of 25 billion rand in order to assist the company in terms of maintaining its balance sheet integrity with the acquisition of the mattress firm. So at that stage, my investment in the company amounted to 55 billion rand, and with the collapse of the share price, my loss therefore amounted to what my remaining shares today are worth. I'm told I'm still the 2nd or 3rd largest shareholder in the group, but of course with a very reduced share price. I have tried since the debacle to be as helpful as I could be in terms of approaching potential investors to invest money in the company to help with the restructure or to expedite it. Now again, this is something that I've been warned, I've got to be very careful to say, but I can refer to several reports by analysts pointing out just how much value there is in the group. And that is over a wide range because one has to make certain assumptions without the benefit of insider knowledge. I happen to know that the bulk of the businesses in the group today originated from the Pepkor stable in terms of their profitability. And I know that those businesses are good businesses, and I think the market recognizes that. But the frustrating thing has been, as pointed out by the previous presenters, that we can't say too much until the auditors have completed A, their forensic investigation, and B, have signed off on the accounts. Each one of us has our own view as to how good or bad that may be, but we are certainly very clearly prescribed from sharing our view. So thank you, Chairman.
Where are you? Can you go ahead from there? Or do you have a slide presentation, do you? We have the text, yeah. But you can make your way here if you like.
Well, if members have this presentation
I think it's
in hard
quicker that
copy,
way.
then it's
Yeah,
then
it's quicker, and
fine
it's not
for
a
me.
very long slide. Is that okay, members?
That's
It's
that's
faster
fine
that
with
way,
me.
yes? I knew you were going to raise that. Let me explain to you the rationale for it. You see, we can put questions to sign off if that's a majority view, but the idea was to hear what the JSE is doing because they will give us insights into how they manage this process, and this will assist us in asking more pointed, focused questions. But we're in the hands of the majority. We think we should have both together. Okay. Tandi?
Chair, we're proceeding very well. Can we have the JSC presentation? It will give us a perspective and...
Okay, go ahead from there.
Thank you, Chair.
If somebody needs to use a projector, you know the time allocations, right? So you make your way before you called upon to the front here, and Alan and Teboho and others will help you. Right. Over to you, Mr. King.
Thank you, Chair, very much. So certainly the JSE shares the concern that the Chair expressed at the outset of this meeting, and we welcome the Joint Committee's attention to this matter as representatives on behalf of all South Africans. I think it bears saying that it's very disappointing that notwithstanding South Africa's extremely highly regarded corporate governance and accounting standards, an event like this could happen, and happen in one of our most respected and largest companies. The JSE is a licensed exchange under the Financial Markets Act. We are, as such, the frontline regulator of activity on our market and the frontline regulator of issuers. I make this point because there are two regulatory hats that we will talk about through this presentation. The first is in relation to issuers, so those are the companies the likes of Steinhoff. We set listings requirements, and we monitor compliance with those listings requirements. In certain cases, like in the case of Steinhoff, companies are dual listed, which means that we are the secondary regulator of them, that they have a primary regulator somewhere else in the world, and we therefore certainly place a lot of reliance on the level of regulation by primary regulators. If you turn to the first page of the presentation, that is the Steinhoff organogram. Mr. Dupree has already given a slightly different perspective on this. I focus on that merely to make 2 points. That Steinhoff has 4 different instruments listed on the JSE. There is Steinhoff International, that's the major, that's the holding company, and in that regard, that is the one that was listed in 2015. It is primarily listed in Frankfurt. That's FSE, is Frankfurt Stock Exchange. That is the major bourse of the Deutsche Börse, the German exchange, secondary listing on the JSE. Steinhoff Investment Holdings has perpetual prefs, also listed on the JSE. They have been listed for many years. And then it has, then Steinhoff Services has a domestic medium-term note, so that's a bond issue, listed on the JSE, also has been listed for many years. Once again, we are the primary regulator of that listing. And then STAR, which Mr. Dupree and Ms. Son referred to, listed last year on the JSE. This is the South African assets of the group. We are the primary regulator of that. 4 instruments, we are the primary regulator of 3 of them. We are the secondary regulator of one of them, and it is in relation to that one, Steinhoff International, that the major issues have occurred. If you then turn to the role of the DMA and the JSE, this starts to deal with the regulatory responsibilities. Before I'll deal with what the JSE has done from a regulatory perspective to date, I think it might be helpful for me to unpack the regulatory framework in the Financial Markets Act in slightly more detail, so that members would understand the 2 different regulatory focuses that we have. So firstly, in relation to the regulatory schema, the Financial Services Board is the primary regulator of market abuse in this country. It has a Directorate of Market Abuse, and the Directorate of Market Abuse has the powers to investigate insider trading, false statements and market manipulation, and I will deal with those and their distinction just briefly. The Directorate of Market Abuse also has the power to institute civil and criminal proceedings. Within the JSE, as the frontline regulator of issuers and of market conduct, there are 2 areas that we look at. Issuer regulation, and my colleague on my left here, Mr. Burke, is the director in charge of issuer regulation, sets the listings requirements and then monitors listed entities' adherence to the listings requirements and then enforces the listings requirements. We also look at whether or not an issuer, a company, has made any false statements. So were an issuer to make a statement publicly or in relation, in a SENS announcement or in a document that they produce that is false, we would take sanction, we would issue sanctions in that regard. And then we obviously also report any potential concerns to the Directorate of Market Abuse for them to take action, because it is the Financial Services Board through the Directorate of Market Abuse that has the powers to issue civil or criminal take civil or criminal action. Our market regulation team is a completely separate team. It is responsible for surveilling activity on the market, what you might call trading activity. And that's activity whether by traders, so members of broking firms, or investors and the like. They are responsible for doing an initial review of activity to see whether there is potential insider trading or market manipulation, and then we report that information to the Financial Services Board, and I know our colleagues from the Financial Services Board here, and they will talk to that slightly later. Our review process does not have powers the likes of subpoenas and the like. We have very detailed, sophisticated systems which track patterns, which are able to monitor at an individual level who's trading on behalf of whom. And so concerns that often get raised with us about, did you know that Bloggs was trading or Smith was trading? We know that. We see that well before the trade is actually executed. It is in the form of that. So, Chair, those are the slides. That's the background, where Steinhoff, what we regulate, and what the regulatory schema is. The Financial Markets Act refers to 3 forms of market abuse, and I think as members of the public, we sometimes conflate this. If you have my letter in front of you, you will see...
King.
Yes, Chair?
You must bear with us.
No problem.
We're not technical experts,
No problem.
right? We are mere politicians. So can you slow down a bit?
I can slow down.
I'm surprised Thandi hasn't intervened. On behalf of Thandi, I'm Thandi's spokesperson here. You're going too fast for me.
No problem,
let
Chair.
alone her.
Can you give, you know why she's galloping? You never give her enough time, and you know that's what we battle about. Can you give Nikki additional 5 minutes?
No, she's got a good half an hour, Ms. Newton-King, and you can manage, yes.
I'll slow down, Chair, and I thought Thandi was well on top of this, so I didn't regulate my...
Don't worry about it.
Right. The Financial Markets Act talks about 3 forms of market abuse, and sometimes as individuals, members of the public, we conflate these 3 forms. It is important to distinguish them. The first is the prescription against insider trading. That is trading in a listed share while in possession of unpublished, price-sensitive information. It typically comes from the company, an employee of the company, an advisor to the company. That's inside information. If you collate information, a view, from public information, that is not inside information. So you create your own perspective on what happened from information that is legitimately in the public, and you have not used inside information. That is not, your view is not inside information. It might be unique, but it's not inside information. The second offence that the Financial Markets Act recognizes is publishing or making false statements. These can be made by the listed company or an official of the listed company. It can also be made by an outsider about a company. So people who knowingly put out information that is not correct in order to mislead, that is false information. The fact that you draw a wrong conclusion, that's a different issue. But you knowingly put out false information, that is the offence in the act of false statements. And then thirdly is market manipulation. Market manipulation, the likes of which we were called, for instance, in relation to a company alleged to be aligned to state capture, where people specifically trade in a particular manner in order to achieve a certain outcome, to suggest there was trading activity when there was not. That is market manipulation. These are three separate offences. We are required to look at all of these, and we do the initial investigation of all of these. When I turn then to our role in this regard in relation to issuer regulation, we have spent, from the 5th of December to date, we have at least one call a day with Steinhoff on issues in relation to disclosures they are wanting to make, disclosures we think that they should make. They have been extremely cooperative. I met last week with the Frankfurt Stock Exchange to discuss with them their approach to regulation, specifically their approach to suspension. And I'll come to that because there has been quite a lot of noise about suspension. We have not engaged with the Frankfurt regulators in relation to auditing, or in relation to auditors, or the Dutch regulators in relation to the Companies Act, or in relation to audit, because Steinhoff International is not primarily regulated by us. It is primarily regulated by the Frankfurt Stock Exchange. In relation to how we have looked at Steinhoff, our focus has been on three things. The first is, has sufficient, accurate information been put out there whenever we possibly, at which, at as reasonable an interval as possible. It has turned out in some of these cases to be reasonably complicated to get it's turned out to be complicated. I'll get there, Thandi. It's turned out to be complicated in one or two cases where Steinhoff has had to issue an equivalent of a SENS announcement in Frankfurt, and to time that so that it was issued at the same time in South Africa. We've now got that right. We have the process right, but there were one or two moments earlier on in the process where there was information released on their equivalent of SENS and not in Johannesburg at exactly the same second. We've really worked hard to make sure that is dealt with. So that Ms. Son indicated, I think, 33 announcements that Steinhoff has released. All of those have been discussed with us and the like. The second focus has been in relation to financial disclosure. Obviously, appropriate financial disclosure is an important aspect of our regulatory concerns. We have, following this, becoming public knowledge, we have had our own financial specialists, accounting specialists, review the accounts to see whether there is anything we possibly missed. and we have not been able to find any IFRS non-compliance at the moment in relation to the accounts that we have seen. We are going to obviously have to wait for PwC's report to indicate whether there are things that are not obvious to anybody that, that they have been able to discover. I should make the point in relation to accounts that the JSE's jurisdiction, and I suspect Urba would make a similar point, ends in relation to Steinhoff International in 2015, which is the last time that it was they were audited under by South African auditors. 2016 and 2017 was by the Dutch. The Dutch would have jurisdiction. The third issue that we have looked at.
Sorry, Chair. Sorry.
Yeah.
I just want Nikki to repeat the point. You're saying 2 fiscal years were not audited by. I'm sorry to ask because I just.
2016, 2017 are under by the Dutch auditors, and 2015 by the South African audit firms. The third point that we have had to apply our mind to is in relation to the possible suspension of Steinhoff. Right at the very beginning, when this entire thing became public, there were concerns about whether or not there was unpublished price-sensitive information that people knew. Shouldn't we suspend because people are losing money? It occurred to us that people think suspension is a penalty on the company, that you suspend like a naughty child at school, that it actually is something that hurts the company properly. But what suspension does is it stops individual investors being able to exit a company, to decide how they are going to mitigate their particular concern. Had we, for instance, suspended Steinhoff on the very first day, people would have not been able to trade out of it. When would we have opened it? At what basis should we have then allowed Steinhoff to trade again? Okay, and what value would it have opened? We haven't even closed the JSE as a matter of principle during 9/11, during the global financial crisis. The general policy is markets should be open, investors should be able to trust that the markets will be open and take their own view as to whether or not it's appropriate to buy a share. When would we suspend? And I mentioned there are four listings on the JSE. We would suspend if we thought there was an inadequate price symmetry, information symmetry. So trading was happening and people did not have the right amount of information. Some people had more information than others, okay? And as we said, we have worked extremely hard, the companies worked extremely hard to get the required information out there. We do not think there is an information asymmetry there. Sometimes one suspends for a very brief moment. For instance, if executives of a company are seen with executives of another company and somebody makes an assumption that they're doing a deal, okay, and that is now all over the Twitterverse, we will get the company to clarify that, suspend, we call it halting, very briefly, and then open the company again for trading minutes later, half an hour later, once they've issued an announcement to clarify something. In this particular case, there are two things to bear in mind. Firstly, the company where this issue is most concerning is in Steinhoff International. It is primarily listed in Frankfurt. The German exchange, and I had extensive conversations, as I said last week with them, will not suspend them, will not suspend for failing to submit financials. They will allow time for those financials to be produced, but they will not submit for failing to suspend for failing to produce financials. If we were to suspend, then the German shareholders who have access to the company overseas will be able to trade, but our shareholders will not. That essentially puts South African shareholders at a disadvantage. So we allow companies. We will allow the company to be available for trade as long as we possibly can. We do not want to prejudice South African shareholders if people can exit or buy overseas if they wanted to. It is a slightly different issue and a different position that we may take in relation to the listings where there is only one listing and we are the primary regulator. In other words, on the other 3 listings. We will review our position in relation to the bonds and the pref shares in due course, and make a decision with regard to whether or not we will suspend that. So, Chair, in relation to the work being done around issuer regulation, I want to assure the committee that there is extensive work, extensive engagement, and we are completely aligned with the view that the primary regulator has in relation to Steinhoff International's suspension and in fact not to suspend it, and we are going to apply our minds separately to the issue of whether or not we will need to suspend the other instruments if the financials are not produced timeously. Finally, then, in relation to our regulatory issues, the question then of market abuse. As I said, we are the frontline regulator. We do preliminary reviews of any strange activity. It always intrigues me that we get enormous amounts of social media. Have you noticed this? Have you noticed that? But the nature of our systems track this before the trades are actually public to the public. So we know where these things are, where this activity comes from, and it is not such that every time there is a strange movement or an unusual movement that means there is any form of one of the 3 market abuses that I've referred to. We have to do the detailed work to discover that. Our market regulation has completed its preliminary review of the trading in Steinhoff ahead of the December announcements of 4, 6 and 10 December. And we have given that information to the Financial Services Board, whom, as I said, they are the ones that have the detailed powers of subpoena for civil and criminal sanction. We work extremely closely with the Financial Services Board in relation to the information we have and the powers that they have. It is a very good collaborative relationship. Steinhoff has to still publish its 2017 results. It has indicated that it is difficult for it to do that until it knows how PwC's forensic investigation is turning out. And once we have both the results and the forensic report from PwC, that may well indicate further need for market conduct reviews, either in December or at any time up to here. This investigation is not going to finish quickly, Chair. This will finish. It will finish once all the facts are clear, and we are a way away from finding out whether the facts we're a way away from getting to the bottom of exactly what happened. I want to just end, Chair, by focusing on 2 things. Firstly, the JSE is completely committed to continuing to work with Steinhoff to make sure that the disclosures as an issuer are timeous, full, and appropriate for the investors to have confidence that there is enough information out there to rely on in order to be able to trade any day that they need to trade. We are also completely committed to finishing the market abuse work and investigations that we need to do. But, Chair, I want to pick up a point that you alluded to right at the beginning, which is whether or not this indicates that there is a lacuna or a failure in our regulatory schema. I'm not convinced that that's what this is showing. Fraud is extremely difficult to catch anywhere in the world, and the literature of economics is littered with cases of fraud. I think there is space for us to consider whether or not the checks and balances that we have already written in our law, in our governance structures, are actually working as they are intended. Do we, for instance, need to think about an increased level of engagement from people like large asset managers? How do they exercise the voice of shareholding, which is to hold the board accountable? How does the board hold really very strong CEOs accountable? Is there more that we should expect in these from these various stakeholders? It doesn't require, perhaps, another single word of legislation, but perhaps a bigger focus on exactly what we expect them to do in order to say we have properly held people accountable. Capitalism, by its very nature, is driven to incentivize performance. And we should celebrate that because it has many good things about it. But it works on the basis that that there are countervailing forces to keep that the way that we operate our companies completely fair and equitable to all stakeholders. And so I think that conversation is one where there is a lot of potential. It's a conversation we have already started with some of the large shareholders, and we will be rolling through a whole lot of stakeholders to see where people how people feel we could do better, because for sure we cannot have something like this happen and rely on the fact that we've got rules and great governance standards and say it must be okay, this was an aberration. So, Chair, I'll stop here and take questions.
With 4 committees and over 40 members here, we're pleading with all members to give everybody a chance, but also give the people invited a chance to reply. This is an initial foray. We will exchange further. So having said that, the 3 chairs are suggesting that each member poses 2 questions. So yes. Thandi, you are no different from the other 40 members here. The chairs themselves will not speak except to facilitate more than 3 minutes at a time. So can we please, sorry, do you want to say something? Do you want to come in? That's right. Yes, as Temba points out, Comrade, if you are precise and focused, you can cover within 2 to 3 minutes your 2 questions. You'll have a second round. Thandi, let's start with you, then Mr. Mania, then Peace Mabe, then Minor, then Mr. Rousseau, David, sorry, and then behind there is my comrade from EFF, your name escapes me, and then Comrade Nyami Boy, and our friend from UDM, Mr. Nkwankwa, and then Floyd, Penki. There you are. You see, already we've got about 14. So look, there's no debate. Can we be pointed and focused? 2 questions, no more than 3 minutes. Thank you.
Chair, I'll try very hard to work in that limited time space.
Just quickly, you can put your questions on in writing also. Within 7 days, you will reply. Thank you.
Chair, I'm going to try. Hey, Chair,
What do you want to comment on? You want to ask 15 questions?
No, I don't wish to belabor this point, but I did warn, or I did recommend that members be given an opportunity to cross-examine witnesses. That proposal was rejected. I just want to, allowing members to only ask 2 questions will have the effect, I think, of diminishing a member's capacity to subject Steinhoff to scrutiny. So the DA are going to yield their questions to me, and I will pose 16 questions. Thank you.
Right. Can I raise something on procedure? We've discussed this thing.
A possibility of
Can we as chairs just rule on this matter?
Oh, sure.
This is an initial foray. This is not the be-all and end-all of our oversight. We've made that painstakingly clear. If need be, Steinhoff will be brought here, if need be, twice a month. They have themselves volunteered to be here. We are beginning to shape a program out of this, colleagues. Let's not unduly cover ground we covered in the Standing Committee on Finance yesterday. So, let's actually agree that there are various ways in which we will get answers. When we've been cross-examined, presumably the Financial Services Board, the Independent Regulatory Board for Auditors, and so on, will do the cross-examination and report to us. We will cross-examine them. But we will also do our oversight role. This is not a commission of inquiry with the status of a commission of inquiry. We made that clear. Having said that, let's move forward. Before we do, can we ask the two chairs to comment? Because it might be seen that it is this one committee chair who's being difficult. Thank you.
No, it's not like that. I think we have agreed that we'll have one person chairing at a time, and we should stick to that. We have agreed that it will be 2 questions per member. That will happen. In an instance where others don't want to ask, we'll move to the next person who has raised his or her hand and proceed in that fashion. And once responses have been given and time permits, we'll allow members to ask further questions. So we should proceed on that understanding. Thank you.
Floyd?
Thanks, Chair. I think let us retain the standard modus operandi on how committees are run, where we ask questions, rather limit the time to 2 minutes, not to 2 questions. So we can say 2 minutes per person, and then within those 2 minutes, you must be able to cover as many questions as possible, and then they take all those questions, and then we agree in terms of how they respond to that, and then we proceed in that fashion.
Can I also suggest, colleagues, it doesn't follow that every member of a party, so if you've got 8 members of the DA, you're going to get 16 minutes. That's absurd. We will prioritize people who haven't spoken or posed questions before, as happens in the Standing Committee on Finance, and I have no doubt you do the same. So can we stick with this? Maybe 2 minutes per person. And here's the clock, and you can monitor yourself. Tanti, get going, please.
Mr. Chairman, I did indicate to you that I wanted to speak. Thank you, Mr. Chairman. Mr. Chairman, just to place on record that I object to this modus operandi, that my 2 minutes and the other members of the DA have been allocated to David, as it is normal practice in Parliament. It's not abnormal. And so in our view, if each member is allocated 2 minutes and the member then waives their right and gives it to someone else, then that is fully in order.
But you see, what we have to be clear about, it is not the case that every member that puts their hand up on every area will speak. In that case, Thandi can say that members are ceding to her. How many ANC members do we have? Yeah. So we could do the same. It's really messing around. Can we just rule? Mr. Jenkins, are you here? Right. Is there anything wrong in a parliamentary committee chair's ruling now? It's 2 minutes per person.
There's no need for the lawyer to advise. Right. The modus operandi Mr. Lees is talking about is what happens in the sittings of Parliament of the House, where you can waive minutes to a certain speaker. In committees, we agree in principle that you speak for 15 minutes, you speak for 5 minutes, depending on what are the time allocations. So we must not be introduced to strange characters because some people want to
Floyd, I think you've covered. Can we move on? Okay, Thandi.
Let's deal with the principal issue in terms of how
no, we are ruling that it is 2 minutes per person, and we will ensure representativity across the political parties and fair allocation of those 2 minutes across the day. Thank you. Thandi, over to you.
Sorry, Chair, I did raise my hand, Chair. Chair, I'd just like to know, is this a joint here? Is this a joint exercise, or is this your committee? Because in Scopa, where I come from, we allow members to have areas of interest and focus. So this was started as a joint exercise. It seems that you are now dominating. In Scopa, our process is to have areas of focus, which we allocate to one particular member. I don't understand why that cannot be done in case of honourable mania.
Fine. Now here it is. The 3 committee chairs met at 13:30 yesterday. Mr. Comrade Matala has explained to you the proposed 3 minutes or 2 questions. So it is a collective decision. Mr. Matala has just explained to you that it is not mine.
It's a collective decision of a small group of chairs.
Right, fine.
It's not
let's put it to the vote. Let's put it to the vote.
Because what it will have is the effect of letting Steinhoff
No, they'll be back here repeatedly.
And I hope that that's not your
intention. Can we just start with the questions? Yeah. Now, can we move on, please? Right. Thandi, can you move on?
Chair, first, because of the limited time, I'll limit my questions to Mr. Viso and to Nikki. First, I want to understand that, are you convinced that there were correct oversight systems in place and were they observed? Because if in terms of corporate governance, if it was observed, this should have not happened. And as a board member, I see that you have decided to underwrite the amount of 55 billion rands. I just want to know, was it also intended to ease the burden on the PIC in a way? And are you convinced that the total assets that Steinhoff is currently holding will convince investors to continue to invest in the company? And are you also convinced that Steinhoff will realize profitability going forward? I think these are just generic questions that are not necessarily market sensitive that you can relate. And to you, Nick, in short, the observations I've made before, if you look at what happened with the Ellerin Group and what happened in many companies, immediately when financials are withheld for any other reason, is because there is something untoward. And I know it's very limiting for you to have suspicion in relation to whether people have submitted or not. But here there's a drop of 90% drop of value. So it doesn't come out of the blue. You were auditing specific fiscal years, and there's a shift all of a sudden that it's not done, the next fiscal year is not done by you, it's done somewhere else. That in itself creates sufficient suspicion to look at this matter. And I'm being very general into how you're going to look at this. It's not necessarily saying it relates to the symmetries that you were relating to, whether it's price manipulation and so on, or market manipulation. But it's just, you see, there's nothing we can say in 2 minutes.
Okay. Fine. Can I put this to the vote? How many of you want to speak, how many of you believe that given the context of this exchange, given that it's an initial foray, given that we will have Steinhoff back again, given that we're going to have written questions put to them, how many of you believe that we should allow people unlimited time or more than 2 minutes? Right. No, I want to put it for a vote. There's no other way of dealing with it. Right. Sorry?
We have agreed on a modus operandi how we're proceeding, and we have started. Let's proceed like that. We're still going to take presentations
yes, but
from
to be
GPF,
fair, Comrade Floyd,
from PIC, from IRBA, from all these institutions.
Exactly.
We can't be, let's proceed.
No. Yeah, no. Do you want to say something?
Yeah, Comrade Chair, my understanding is that the 2 minutes will assist us to allow more members to make inputs. But with time, we'll be able to come back. We'll have a second round, a third round, but ensure that you don't concentrate time on 1 or 2 people. So I think let us continue. I'm sure Comrade Tobias, when everybody's done, will probably come back to you and you can continue. Same thing with everybody else.
Okay, I take it the vast majority agree with us, right? Apart from the DA, it seems the vast majority agree. There's no need to put it to the vote. And Mr. UDM?
I just like the fact that Thandi, Honorable Tobias, realizes that there isn't much that you can say in 2 minutes. Maybe she should say that for parliamentary debates for smaller parties.
I think, in fairness, we have said this in SCOF, the smaller parties can get a bit more time. We allow some latitude. So UDM can have 3 minutes or so. Fine. Can we move on? Right.
Can I check, Chair, can I, if I may, because I can see that we're not dealing with the issue that we're intending to deal with. Are we here as committees or political parties? Because that one then is going to be a wrong space that we're entering in. I would suggest that then let's proceed. Whoever wants to come back will come back and respect the Chair in terms of...
Okay, look, the vast majority are agreeing. The DA must just accept that this is a democracy and they have no choice but to accept the views of the majority. Over to you, Mr. Mania. I'm going to monitor you like everybody else.
Thank you, Chair. I warned that these hearings would be a shambles, and they're turning out to be exactly that. Let me start, Chair. The narrative that we've been offered today is that on the 5th of December 2015, there was a bolt from the blue. In JSE's presentation, the very beginning. And the narrative that we've been offered is that Marcus Jooste allegedly committed a massive fraud, that nobody else knew anything. On Mr. Van Zyl's version, the directors were bamboozled. I think the truth is going to be different, and I hope I'm wrong. I think that the truth, when it emerges, is that Marcus Jooste probably was at the center of a massive corporate fraud, but that he had accomplices. That in fact, for more than a decade prior to the bolt from the blue, there was a history of questionable business practices and bullying and strong-arming critics in the market.